continuation with the previous two presentations, particularly focusing on Maldivian issues by Ankit Malhotra from University of London.
I hope I am audible, and I do have slides from which I should need technical assistance. Okay. But before we start, let me just thank everyone for coming here to Maldives. It's a fantastic occasion to combine this with a small vacation and also enjoy the beautiful weather here. Coming from London, I do thoroughly enjoy this hot environment, warm environment, and also
Dua kali aja, satu candid, satu ngadu kamera.
island. I'd also like to lightly submit the points which you made in the first paper on India's relationship, the Supreme Court's relationship with international law, and recommend my dear colleague to refer to Mr. Gopal Subramanian's chapter in a book that I co-authored, where he speaks about this relationship in depth and refers to the relationship and the growing relationship that it has, rather than the congruence which was posed as suggested. Perfect, thank you. Well, once again, I thank the organizers for this opportunity, and also it's a pleasure to be here in Maldives. And I must admit, having my parents in the room is something that brings me fond memories of tutelage and also obedience. Tutelage and obedience also reminds me of someone like Sir Winston Churchill, who once famously wrote that a good speech should be like a, well, he used a girl's skirt, but big for whatever he fancies you, and the speech should be long enough to cover the subject but short enough to create or maintain your interest. And this is something which he referred to when he was serving in the Indian Army in the 35th Sikh Regiment in the autumn of 1896. Now this paper does not have much to do with Churchill, but I just wanted to refer to that as a sort of an opening quote. And I do want to move to the next slide. Well, while we figure out the technical issues, I'd like to start with referring, but not spending too much time on the details of Maldives and Maldives' history, as that has already been covered, only to suggest the unique amalgamations that this country has with its Islamic laws and common laws, which it has from its former empire, which famously is also the same that the Indians adopted. And as I was preparing for this paper, I was reminded of our chair's snappy and quite short and incisive piece on the reduced or the reducing trust and faith in the international legal system when he wrote about the Indian modifications and declarations of jurisdiction in the International Court of Justice. And I think the same sort of same discussion, or at least the same sort of sentiment, continues into the Maldivian system as well, albeit with its separate and specific changes. But the cultural and the religious identity of the nation is also something that necessitates a nuanced approach to international legal interpretation and application, particularly which aligns with laws of international legal standards. And in this respect, what becomes important to study, and at least for this paper, which I shall limit only to topics which have not been discussed so far, which limits the discussion of this paper significantly, albeit have a much more potent discussion in it. And in this respect, I'd just like to refer to the international norms and human rights standards, which the Constitution of 2008 of this honorable country moves towards strengthening the democratic institutions and the rule of law. The then President, Ibrahim Mohammed Solih, pledged to tackle corruption and advance human rights, and has struggled with the influence of Islamist groups. And in this respect, the Max Planck Institute of International Law and the Rule of Law, where I have the honor of attending and studying, in its 2023 report, emphasizes the rollback of fundamental rights, freedoms of speech and assembly, and the rights of LGBTs individuals and also communities. That being said, the Maldivian Penal Code, for instance, criminalizes consensual same-sex conduct and also reflects challenges in aligning with the domestic laws and international human rights standards. Of course, the Islamic laws and the emphasis that they've had on this country play an important role in understanding and also determining the kind of laws that the country will adopt in its near future. But that is not something that I want to spend much of my time on, especially since the other papers have given enough credence to these topics. Therefore, I should limit my discussion to small island developing states and also the Maldivian commitment to reaching its target of net zero emissions by 2030 under the Paris Agreement, which demonstrates its engagement and also congruence with international environmental law. This paper, therefore, explores the complexities and challenges of the interaction in which the international laws are incorporated in international laws and therefore implications, therefore, to the domestic governance and international relations that it has. Again, returning to Lord Bingham is someone who Mr. Gopal Subramanian covers in his chapter on India and the Indian Supreme Court and international laws engagement, offers some sort of a roadmap in some sense of how the legal system has progressed not only domestically but also internationally. Therefore, I am not committed an amount of time to discuss all these topics, but perhaps one that becomes interesting is compliance by state. Now, what this reference to by Lord Bingham is, in the context of Maldives, the judiciary's ability to conduct fair trials, free and from political influence, which is pivotal, but also the principle which is crucial for both domestic and international confidence in the Maldivian legal system. Therefore, by the 6th and 7th December of 2021, the Max Planck Foundation again convened a second series of discussions and dialogues for specialized sessions of law in Maldives in collaboration with the Department of Judicial Administration and the Judicial Academy here in Academy. Therefore, also strengthening the discussion that it has with international law. And this is again something that the Indian counterpart is also famous for doing in his National Judicial Center in Bhopal. We're therefore applying Lord Bingham's points and the principles that he lays down reveals both the complexities and also the challenges that are in face of judicial independence and human rights in the exercise of power that the country exercises. What about the legal system? Now, again, this is something, the history is something which has been covered, so I don't want to spend too much time, only to emphasize what SOAS's leading professor, Professor Werner Mensky, spoke about the historical intertwining of religion and law, which is illustrated by him. And he notes that the influence of Islamic principles on systems such as those of the Maldivian legal system, emphasizing the role in shaping the social norms and legal processes of this country. This, according to him, underscores the dynamic nature and legal interpretation of Islamic jurisprudence in a seminal work on Sharia law. This has also been discussed further and signifies the kind of trajectory that the country has adopted in terms of expanding, understanding, and also assimilating international legal principles into its own system. But of course, there are challenges such as those of the laws of blasphemy and strict restrictions on freedom of religion present in other areas and other conflicts within the international legal arena. This tension on blasphemy and international human rights norms have been a subject of intense legal scrutiny by professors such as Harnai Badfeld, who was the former UN Special Rapporteur on freedom of religion or belief. Someone also, again, I had the opportunity to engage with when I was in the UN last summer. However, all hope is not lost because reconciliation efforts are essential to the development of more inclusive and pluralistic international legal frameworks. Again, something that Professor Werner Mensky formidably submits. Now, adherence to the rule of law, and perhaps there are better more able scholars in this room who can speak about this, and the Maldivian Constitution, specifically Article 68, which emphasizes the rule of law and also the protection of human rights in accordance with international law. But this again raises further examples of congruence, but also of dissonance. But a similar example also rests in the South African example and apartheid, which is often cited as a strong alignment of international human rights standards, therefore offering in some sense an example wherein both laws and also principles can come in charge. Maldives has also submitted its application to intervene in the International Court of Justice in the Gambia versus Myanmar case, which also offers a poignant point where the Maldivian respect but also support to international standards is acknowledged and also appreciated. Equality and human rights I shan't discuss because this is a topic that is going to come up again and again in this discussion and also group. But perhaps to end with, to emphasize the common but differentiated responsibilities and also the loss and damage mechanisms of the United Nations, emphasize the role that a country like Maldives can play, not only on the international sphere, but also amongst other small developing nation states, and the funding mechanisms that such states require. Perhaps, at least in my humble opinion, the state should intervene in the International Court of Justice for its advisory opinion on climate change, and also in other forums such as those as the International Tribunal for the Law of the Sea. But to summarize this rather archipelagic paper, if one can put it like that, the Constitution, the statutory laws, the regulations form the backbone of this hybrid legal framework. International treaties, such as those not discussed in this paper but discussed prior to this, are also something which are now coming into the legal framework. But perhaps the most important system which remains is that the honor and respect that the system has, not only for itself, but also in terms of the utility of international law, not only for its benefit on aspects such as climate change, but also aspects of human rights, especially with the intervention in the International Court of Justice via its able counsels, Professor Philippa Webb and Juan Amal Clooney. Balancing these Islamic traditions with the exigencies of modern international law is a delicate yet essential task. Moreover, international collaboration remains pivotal, especially in addressing overarching issues like climate change and human rights, which I have highlighted in this paper. With that, I thank the organizers once again for giving me an opportunity to share my thoughts, and also to everyone here in the audience for their patient listening. Thank you.
Thank you, Mr. Malhotra, for getting into some of the details of the relationship between international law and domestic law. That's the core of the implementation part of international law, because it has to come back to a state to execute what they have